You're listening to the Valley Current.
Imagine a federal jury verdict form, right? And it's determining billions of dollars in damages.
Huge stakes.
Exactly, massive stakes. There are 98 rows on this document, and 97 of those rows are filled out in standard, clinical black ink, like you'd expect.
Right, totally normal.
But one row, and exactly one row out of all of them, is written in giant, bright blue marker. And the number written there is $4.20.
Oh, wow.
Yeah. So welcome to this deep dive. Today we're looking at a fascinating and frankly a completely bizarre intersection of extreme wealth, extreme notoriety, and the American justice system.
It's just a profound visual anomaly, on what is supposed to be like the most solemn document in our legal process. I mean, when a federal court hands down a verdict, the system relies entirely on this illusion and ideally the reality of blind, sterile justice. And a giant blue meme on a damages sheet just completely shatters that.
It really does. So we're pulling from a really compelling piece of source material today to help you, the listener, understand how this actually happened and, more importantly, why it matters.
Definitely.
It's a special report from the Computer Law Group, or CLG, their Technology and Law Bulletin. And it was written by their managing partner, Jack Russo, back in the spring of 2026.
Right. Great piece.
Yeah, it's fantastic. And our mission for this deep dive is to basically explore the mechanical specifics of this recent securities fraud trial, specifically the Pampina v. Musk trial.
Right.
And we want to unpack the massive structural questions it raises about whether hyperpolarizing figures can, actually get a fair trial in the modern era.
Yeah, and before we dive into those legal mechanics, there is a crucial baseline we need to establish for you, the listener, because, Jack Russo's analysis touches on Elon Musk, who is unequivocally a highly charged political and public figure.
Oh, absolutely. And let's make this absolutely clear right now. Neither of us is taking a side here.
Not at all.
We are not endorsing any political viewpoints, left or right. And we are not defending or attacking anyone's character. We're acting purely as your guides today.
Right, just impartial observers.
Exactly. Impartially unpacking the legal analysis, the factual events, and the systemic stress tests exactly as they are reported in this CLG newsletter.
Because our focus is entirely on the machinery of the law. What this source material reveals isn't really a story about a tech billionaire at its core.
Right.
It's a fundamental examination of whether the traditional tools of the American courtroom are buckling under the weight of the digital age.
Well put. So let's set the stage with the actual facts of the trial before we get to the controversy itself. So March 20, 2026.
Okay.
An 8-member Northern District of California jury returns a unanimous verdict. They found Elon Musk liable for securities fraud.
Right, and we need to look closely at the specific liability the jury assigned here because it shows they were actually parsing the arguments, which honestly makes the blue ink anomaly even stranger.
Right. Because the lawsuit centered around Musk's $44 billion acquisition of Twitter. And specifically, a tweet he sent on May 13th, 2022, where he stated the deal was temporarily on hold.
Yeah. And the plaintiffs came into the courtroom with this massive, sweeping theory, like a scheme to defraud narrative.
Oh, they went big.
Exactly. Alleging that Musk orchestrated a multi-month intentional plan to manipulate and drive down Twitter's stock price so he could renegotiate the acquisition.
But the jury explicitly rejected that broader narrative, didn't they?
They did. They declined to find that he orchestrated this massive scheme. They limited his liability strictly to the misstatements about the merger timeline, specifically those tweets in May. So, they were actively filtering the legal theories. They weren't just rubber stamping everything.
Right, which is what makes the damages phase so completely contradictory.
Yeah.
Because the jury didn't just hand down a flat billion-dollar fine.
No, it's much more mechanical than that.
Right. They had to calculate damages based on when each class member traded their Twitter stock. So mechanically, they had to assign a per-share deflation figure to each of 98 distinct trading days.
Yeah, it's quite a spreadsheet.
Literally a spreadsheet with 98 rows, and they had to write in a specific dollar amount for how much they believed the stock was artificially deflated on that exact day.
Right, and for 97 of those days, the jurors did exactly what you would expect. They calculated the numbers and wrote them normally in standard black ink.
But here's where it gets really interesting. For August 9, 2022, they wrote the deflation amount as $4.20.
Yep.
And like I said, they wrote it in bright blue ink. noticeably larger than every other number on the page.
It's wild.
I'm trying to think of how to picture the impact of this. And it's like, imagine a referee officiating a high-stakes football game.
Okay.
And instead of just calling a penalty, they wink at the camera and do like a mocking dance. Right. It stops being about the rules and starts being about the player's reputation.
Yeah.
Or like a structural engineer signing off on load-bearing calculations for a skyscraper.
Okay.
And right in the middle of the stress coefficients, they draw a derogatory caricature of the building's owner.
Yeah, that completely casts doubt on the mathematical foundation of everything else on the page.
Exactly.
What's fascinating here is it forces you to question whether the math was actually math or just a vehicle for personal commentary. And legally, 420 is not just a random sequence of digits.
Oh, definitely not.
Alex Spiro, who is the lead counsel for Elon Musk, detailed the significance of this in a 7-page letter he filed on March 26 to Judge Charles R. Breyer.
The trial judge.
Right. That number is a highly specific, notorious callback to 2018 when Musk was sanctioned by the SEC for claiming he had funding secured to take Tesla private at $420 a share.
It's pure internet lore at this point. And by putting it on the verdict form in giant blue ink, Spiro argues it became a mocking reference. It transforms the verdict from a clinical calculation of securities fraud into a commentary on the jury's personal views about the defendant.
And this creates an immediate massive headache for the federal court system. Because normally, if a lawyer suspects a jury was biased or, making jokes during their deliberations, they run into this brick wall called Federal Rule of Evidence 606B.
Wait, 606B. Why can't a lawyer just subpoena the jurors and ask them what the blue ink meant? I mean, if the Sixth Amendment guarantees an impartial jury, shouldn't the court want to know if the jury was just trolling the defendant?
You'd think so, right. But the justice system aggressively prioritizes the finality of a verdict. Rule 606B is basically an anti-harassment shield.
Okay, how so?
Well, historically, courts realized that if lawyers could overturn verdicts based on what happened inside the deliberation room, wealthy litigants would simply hire private investigators to hound jurors at their homes for months after a trial.
Oh, wow. Yeah, that makes sense.
Right. They'd be desperate to find just one juror who admits someone made a biased comment. So, to prevent that absolute nightmare, the law essentially seals the jury room. Jurors generally cannot testify to impeach their own verdict.
So under normal circumstances, a joke told inside the jury room essentially never happened as far as the appellate courts are concerned.
Precisely. But Jack Russo's CLG analysis highlights a fascinating mechanical loophole here. The blue ink joke wasn't just spoken in the deliberation room.
Right.
The jurors physically wrote it onto the verdict form itself. Yeah. In legal terms, it acts as extrinsic evidence. It is baked into the four corners of the official court document that the judge accepted.
So it documented itself.
Exactly. Because the anomaly documented itself, Musk's team can point directly to the court record, potentially bypassing the protections of Rule 606B entirely.
That is wild. The jury essentially provided the defense with the exact key needed to unlock their own deliberation secrecy.
They handed it right to them.
But, this connects to a much bigger, much more concerning structural question. If we have a jury that feels completely comfortable color-coding an internet meme onto a federal damages document, how did that specific group of people make it through the screening process to begin with?
And that is the core of Alex Spiro's pre-trial concerns. I mean, this trial took place in the Northern District of California, drawing from the San Francisco jury pool.
Okay.
During the initial jury selection, or voir dire, the court used questionnaires to screen potential jurors. And Spiro's letter documented that these questionnaires revealed a hostility toward Mr. Musk that ran wide and deep throughout the pool.
Wait, hold on. The Constitution guarantees the right to an impartial jury?
Yes.
If the judge saw the questionnaires and knew the hostility was deeply entrenched in this specific city, how is it legally permissible to seat them? Why not just dismiss every juror who showed bias? Or, simply move the trial to a different state?
Well, the CLG report maps out this bizarre logistical trap the court found itself in. Judge Breyer actually observed on the record, before the trial even started, that the San Francisco jury pool might yield a completely different panel than anywhere else in the country.
Right.
But the community antipathy was so dense that excusing every single hostile juror was mathematically impossible if they actually wanted to hold a trial. You would literally run out of people.
Wow. So what is the mechanical solution when a court literally cannot find 12 unbiased people in a city?
According to Spiro's filing, the court quietly adjusted the threshold.
Really?
Yeah. During jury selection, lawyers have a limited number of peremptory strikes to remove jurors for any reason, but they have an unlimited number of strikes for cause, meaning the juror is demonstrably unable to be fair.
Okay, got it.
But the judge has to agree to a strike for cause. And because finding neutral people was so incredibly difficult, the standard for what constituted cause was effectively raised. The bar for acceptable impartiality had to be lowered just to get the trial underway.
That seems to violently contradict the entire premise of the justice system.
It does.
I mean, Spiro's arguing that the logic was completely inverted.
Right.
Right. If you are operating in a jurisdiction with extreme documented bias against a defendant, the standard for impartiality should be rigorously heightened, not quietly relaxed just to keep the trial on schedule.
That's his exact argument.
His letter explicitly notes that even prospective jurors who admitted outright bias on their questionnaires were not excused for cause.
Yeah.
Which forced the defense to burn their limited peremptory strikes just to remove people who had already confessed they couldn't be fair.
You are hitting on the exact constitutional tension here. The defense argues that the mechanics of jury selection were compromised by the venue itself. But, moving a trial is incredibly difficult in the federal system.
Because of precedent.
Exactly. It's largely due to a key Supreme Court precedent from 2010 called Skilling v. United States.
Oh, Skilling. That was the Enron case, right?
Yeah.
Jeffrey Skilling was one of the most hated men in Houston after the company collapsed and destroyed thousands of local jobs and pensions.
He really was. And Skilling's lawyers argued he couldn't possibly get a fair trial in Houston because the local hatred was just too intense. But the Supreme Court ruled against him.
Wow.
They established a precedent that basically says, look, Houston is a massive metropolitan area with millions of people. Just because a community is heavily exposed to negative news about a defendant doesn't automatically mean you can't find 12 impartial people. So courts lean heavily on Skilling to deny venue changes.
But the problem with applying a 2010 precedent to a 2026 trial is that the mechanics of notoriety have fundamentally changed.
Completely.
Right. In 2010, negative news meant you saw Jeffrey Skilling on the local evening broadcast, or you read about him in the Houston Chronicle. You could just turn the TV off.
Right, you could opt out. Jack Russo's analysis drives this exact point home. The legal framework of Skilling was built for the newspaper and television era. It is arguably completely unequipped to handle a figure like Elon Musk in the digital era. Yeah.
Musk doesn't just appear in the news. He actively shapes daily political and cultural discourse on a social media platform that he personally owns.
Right.
And he does this relentlessly right in the exact metropolitan area where the trial is being held. The algorithm delivers his controversies directly to the pockets of the jury pool every single hour.
Every single hour. It feels like the federal courts are trying to regulate a social media algorithm using rules written for a printing press.
That's a great way to put it.
And looking at the CLG report, this structural dysfunction wasn't just isolated to the jury box, was it?
No, not at all.
The lawyers themselves were navigating some highly unusual procedural tactics.
Oh, the courtroom maneuvering was intense, particularly regarding the disqualification of Alex Spiro from his role in front of the jury.
This is a fascinating mechanical breakdown to me. So Spiro is Musk's lead defense counsel.
But before the trial gets going, the plaintiff's lawyers file a motion claiming that Spiro isn't just a lawyer. They claim he is actually a critical first-hand witness to the events surrounding the Twitter acquisition.
And this triggers what is known in legal ethics as the advocate witness rule.
Okay, what does that mean?
Well, the American Bar Association's model rules of professional conduct generally prohibit a lawyer from acting as an advocate at a trial in which the lawyer is likely to be a necessary witness.
Wait, why does the system care if you do both?
Because it short-circuits the jury's brain.
Oh, I see.
Yeah, I mean, a lawyer's job is to persuade, to argue, and to spin the facts in favor of their client, right?
Right.
A witness's job is to sit on the stand under oath and state objective facts. If one person tries to do both, juries struggle to separate the persuasion from the testimony.
That makes total sense.
It either gives the lawyer's argument unearned factual weight, or it makes the objective facts look like partisan spin. It's just highly prejudicial.
So faced with the threat of prejudicing his own client or violating ethical rules, Spiro voluntarily steps back. He benches himself from the jury-facing role.
He does.
But the kicker here is what happens next. After Spiro steps down, the plaintiffs never actually call him to the stand. Not once.
Not a single time. They eventually confirmed they had no intention of calling him as a witness at all.
That's unbelievable. It's like finding a zero-day exploit in the court's ethical software.
Oh, totally.
It's like a football team pretending to challenge a play just to force the opposing team's star quarterback off the field on a technicality and then never following through with the challenge. They triggered an automated safety protocol, the advocate witness rule, to completely crash the defense's operating system and sideline their lead attorney without ever actually executing the file. They just used the threat of the rule to alter the playing field.
The CLG newsletter characterizes this as a serious issue of procedural weaponization. I mean, the tactic successfully deprived Musk of his chosen lead counsel during the critical jury-facing portions of the trial. Furthermore, it deprived the defense of a key witness whose firsthand testimony could potentially have been used to rebut the plaintiff's allegations.
And the report suggests this demands serious judicial scrutiny. Because if courts allow ethical safeguards to be used as tactical swords to eliminate opposing counsel, it compromises the integrity of the whole adversarial process.
It creates an environment where the rules of procedure substitute for legitimate debate over the facts. And, if we're examining compromised environments, Jack brings in one final, incredibly strange puzzle piece.
Yeah, the dysfunction wasn't contained to California, right? It spilled over into the Delaware court system.
It did.
And this involves Chancellor Kathleen McCormick, who presides over the Chancery Court in Delaware. She's a towering figure in corporate governance.
Huge reputation.
And she happens to be the judge handling completely separate but massively consequential shareholder actions involving Elon Musk.
Right, and we need to clarify this for the listener. Unlike a federal jury trial, the Chancery Court in Delaware does not use juries. The Chancellor herself is the sole finder of fact. So her impartiality is the entire foundation of those proceedings.
Which makes this next part so messy, because after the Pampana v. Musk verdict comes down in California, a jury consultant for the plaintiffs posts a celebration of the guilty verdict on LinkedIn.
Yep.
And Chancellor McCormick's official LinkedIn account interacts with that post. She specifically used the support reaction, like, the icon of a heart floating over an outstretched hand, to endorse a post celebrating a guilty verdict against a defendant currently standing trial in her own courtroom.
Yeah. And when a motion was filed demanding she recuse herself from the Delaware cases, she stated that she either did not click the button or did so accidentally while scrolling.
Right. But regardless of whether it was an accidental screen tap, Alex Spiro took the extraordinary step of weaving this Delaware LinkedIn incident into his federal filing in California.
He did.
Why does a Delaware judge's social media activity matter to a federal judge in San Francisco reviewing a jury verdict?
Because Spiro is synthesizing a much broader narrative here about institutional integrity, Jack Russo's report identifies this as crossover risk.
Crossover risk.
Right. When you are dealing with a defendant possessing unprecedented wealth and digital notoriety, their legal battles are interlocking. The lawyers, the judges, and the consultants all exist in the same professional ecosystem, and they all consume the exact same social media feeds.
So Spiro is using the chancellor's heart emoji to point out that if even a highly sophisticated Delaware judge cannot maintain the appearance of strict neutrality in the digital space, how could a random pool of San Francisco citizens possibly be expected to do so?
Exactly. It highlights why the justice system is obsessed with appearances. The system has to not only be fair in practice, it has to appear completely unimpeachable from the outside to maintain public trust.
Right.
When crossover risk bleeds across state lines and social networks like this, that public trust erodes.
We have covered a massive amount of legal ground here, and it is really vital to synthesize the journey we just took for you, the listener.
It's a lot to take in.
It is. We started with a federal jury writing an internet joke in bright blue ink on a damages calculation. We explored how a federal judge, trapped by demographics, quietly lowered the standard for an impartial jury because the local community was too universally biased.
Right.
We unpacked how lawyers weaponized ethical rules to sideline opposing counsel like a zero-day exploit. And we saw how crossover risk led to a Delaware judge accidentally cheering on a guilty verdict online. So what does this all mean?
Well, the through line connecting all of these anomalies is the immense strain that digital mega notoriety places on traditional judicial mechanics.
Yeah.
The verdict in California currently stands, and appellate courts are historically loath to overturn jury decisions. But Jack Russo's analysis leaves us staring at an unresolved structural crisis. The federal courts operating under the traditional rules of Article 3 rely on venue changes, jury questionnaires, and ethical firewalls designed decades, if not centuries ago.
Which leaves you, the listener, with a profound, systemic question to mull over. We live in a hyper-connected, algorithmic world. You instantly know everything about a polarizing public figure, and your digital feed has likely entrenched your opinion before you ever receive a jury summons in the mail.
And in that reality, the foundational concept of an impartial jury of your peers from your local community might simply be mathematically impossible.
Does the American justice system need a fundamental redesign for the digital age? Could the future of high-profile tech litigation require professional sequestered juries?
Or maybe a completely new venue system entirely.
Right, a completely new national venue system, specifically designed to handle trillionaires whose influence transcends geography. Because if we don't adapt the underlying mechanics of the courtroom to the reality of the algorithm, we might just have to get used to verdicts written in bright blue ink. Thank you for joining us in this deep dive. Keep questioning the structures around you, and we'll catch you next time.
Tune in next time on The Valley Current.